Welcome everybody to the HelpSystems webinar, Preparing for GDPR, the first steps to GDPR compliance. I'd like to thank you all for joining me today and taking time out of your busy schedule to join us. Now I say us, there's two people on the call. There's myself, Donnie MacColl. I'm the Director of Technical Services in EMEA for HelpSystems. And I also have a guest as well, Peter Gothard. He's the Special Projects Editor for Computing. A number of you already know Peter. The reason I've asked Peter to join me today is he has experience in so many different areas. It surprises me every time I talk to him. But he also has some unusual angles on some of the topics that we'll be covering today. So thank you, Peter, for joining us as well.
Thanks, Donnie.
Right, we've got a lot to cover in just over 30 minutes. So if I talk very quickly, I do apologise. The agenda today is covering what is GDPR and its purpose. I'm going to hone in on the 8 rights of GDPR, and these are rights that apply to you as individuals. And there's some very strong, very forceful rights that we have as individuals and how our data is processed. We'll touch briefly on what GDPR means for businesses, and then we'll look at how we can start preparing for GDPR as well. So a couple of areas that we can touch on that gives us a bit of a starting point as to make the whole process less scary than it really is. There's just one slide on the GDPR implications. Now, if you have a data breach, and when it says implications, read into that fine, read into that enormous fine. So we'll cover that as well. And then there's an offer for everybody attending the webinar today as well. Time permitting, we'll have a Q&A session. If we don't have time, any questions that you do send in using the chat feature, we'll follow up on individually after the event. So what is GDPR? GDPR, what is its purpose? Well, it's as you can see there, it's a new EU legal framework which replaces the current Data Protection Directive. Now, the Data Protection Directive is 9546 EC. The important bit there is 95. First to 1995 when it first came in. And as you can imagine, the digital transformation that's happened since then, just the way that we carry out our working lives is very different since 1995. There's a lot that's changed. So it's not before time that we had a new framework coming to replace that directive. It actually comes into effect in May 2018. However, it's here now. So it started in May 2016. We have 2 years to actually comply with it when it actually starts on the 25th of May 2018. And it always surprises me how many people haven't done anything about it. Hopefully by the end of the webinar today, you'll know much more than you did. The whole idea of GDPR is to protect your personal data. And it's all to do with you. It really is a personal thing to make sure your personal data is secured. It's to be accountable for how organisations process your data, how they destroy your data when it's no longer required. And it also includes governing rules and what happens to your data when it's transferred between EU and, really importantly, non-EU locations as well. As I mentioned before, we'll cover the fines as well if you do have a breach. This is the official statement copied from the GDPR document. I didn't add the capitals, they're already in there, and you can see that it's for the protection of natural persons, i.e. us, and how our data is processed and the free movement of such data between EU and non-EU countries as well. Some statistics, 261 pages long. I've read most of them. There's over 56,000 words. And I was asked what I meant by 35 pages, you telling you what we're about to tell you. I refer back to a really famous British broadcaster, Trevor McDonald, who I remember seeing a documentary when he said, when I tell the news, I tell people what I'm going to tell them, I tell them, and then I tell them what I've told them. Well, the GDPR document, the first 35 pages or so, tells you what it's going to tell you. Now, the reason I'm telling you that as well is it has to be written in plain English, or the terminology is actually plain language. So GDPR is as plain language as it possibly can be, so we can understand it without having too much legal representation, and it determines that any policies that we put in that help us comply with GDPR and in plain language as well, so that everybody, including employees and also people who are affected by GDPR, can understand. Who does GDPR apply to? Well, everybody's on this call for sure. Everybody who has a physical presence as a business in the EU, or at least in one member state of the EU, or, not and, but or anybody who processes or stores data for individuals who reside in the EU, or if you use any third-party services. So if you're signed up to Salesforce, that applies as well. It, in plain language, it applies to any organisation, not just in the EU, if you've got a computer, and it also applies pre- and post-Brexit. It also applies to US organisations, and in fact, any organisation. I've used US because the HelpSystems I work for is a US-based organisation dealing with people like myself, actually in Europe. There is a difference between a regulation and a directive, and I wonder, Peter, if you would jump in just to help the viewers with this.
Will do. Yeah, I've been hard at work on Wikipedia to absolutely nail this one down. No, it's really quite simple. As it states, a regulation has a binding legal force throughout every member state and enters into force on a set date in all member states. A directive is more something that has to be achieved, the same as a regulation, but the member state is allowed to choose its own way to actually get there. So it's a lot more open to interpretation. It's a lot more open to kind of finding your own nuanced way to actually achieving it, which I guess makes it both easier and harder in a way than just being told, do it.
Yeah, I agree. I guess with a regulation, with it being law, it's a defined set of rules. But yeah, certainly some interesting times ahead. I've tried to sum up what it meant to us and as businesses and employees as well as individuals. And really, it's that we must treat personal data with care. And there's a number of areas that we can do that, listed at the bottom. Data security, I mentioned, is really just old-fashioned IT. That's just making sure that any data that we store or process on individuals, that we look after it, make sure it's secure, make sure that we have security measures in place to stop people actually accessing that data who shouldn't see it or be able to process it. The data minimization, let's keep as little as we possibly can. And this is one of the hints and tips will come up as well. We really need to minimize the amount of data we've had on individuals, and that will make our job much easier. GDPR means we have to prove that we comply with the rules of GDPR. As Peter mentioned, with the Data Protection Directive, it's kind of this is the direction you should be going in and implement it how you like. With GDPR, it's the law. You have to comply and prove that you're complying. Breach notifications, we have to actively notify people and the supervisory body that there's been a breach within 72 hours of a breach occurring, as soon as I've been aware of it. And then we have the data subject rights, which gives you lots of rights, the 8 rights we mentioned, and we'll touch on very briefly during this presentation. The 8 rights that apply to us as individuals, and then other is really just things like where you may or you do have to appoint roles to ensure that GDPR is followed properly. I'll just go on to the 8 rights. I know Peter's got a comment or two to make on this slide, so I'll just make a start. The 8 rights, and I apologise talking very quickly, as I mentioned, we've got a lot to cover. The right to be informed, this is your right, and this is the right to be informed as how your data is going to be used, importantly, at the first point of contact. So whether your first point of contact with a business is a website or a telephone call, you have to be notified either by the means of a privacy policy, and I will say an updated privacy policy now, that has to be concise and has to be intelligible and has to say what data we're going to store, how we're going to use your data, how long we're going to keep your data for, amongst other things. You'll know if you phone somebody, perhaps an insurance company, and they say we may record this call, they will have to inform you of the privacy policy at the first point of contact. Now, it isn't as bad as it sounds. You can have abbreviated versions of the privacy policy as long as you direct people to the more extended version. The right to access is your right to access your own data. So this is data that you have provided, and you can have access to your data. You'll be told how it's used, and supplemental data that may be associated with you. An example being, I know when I applied for a mortgage, and I looked at the credit check file because she had applied for a mortgage, and the supplemental data specified that my wife was also an interested party. So I with this right, would have to know that. A couple of interesting ones there. Peter, do you want to talk on rectification or the right to erasure? Any of them you want to chip in on?
I mean, for me, like, these first 4 points generally are kind of where GDPR is really going to be the most challenging, because while it's all great common sense and it's really, really good, and it's kind of what we always probably should have had as human beings, because it just makes sense to have control over your own data. But from kind of CIOs and also lawyers that I've spoken to a lot about this over the past year or so, the real problem is just how mired organizations are going to be in kind of their own old way of doing things, and how you're going to keep finding kind of legacy processes that are in place that you've never thought of that are actually blocking this from happening. So, you know, it might be like, well, yeah, okay, great, we understand that we have to, you know, rectify, change or erase data, but because it may be held in a third party's servers or, you know, in a place we can't easily get to it, it's just going to be like untangling a ball of wool, really, to actually, you know, especially in such a short amount of time. So it's just something that's going to require probably some of the most thought, I think, of any of these kind of rights and directives.
I agree with you totally, Peter, especially with the right to erasure, to have any data held about you removed.
Huge.
Right, massive, isn't it? Yeah, absolutely huge. Yeah. Right, we'll move on to the other 4 rights you have, the right to restrict processing. Now, this is quite a neat little right. It means that people can still store the data that you provided with them, but you can stop them processing that data. Now, as Peter mentioned, some of these are really far-reaching and will be quite difficult to implement. The right to restrict processing means you can ask, or you can actually use your right to say, stop processing my data. Now, that means that the people that are processing your data have to have an audit trail of who they've actually shared that data with, and they have to notify them and the companies to say, you're not allowed to process this data anymore. Now, that might be because you're thinking of using one of your other rights. You might think that the data they held about you is inaccurate, and it's actually up to the companies who hold that data to prove it's not inaccurate or to just stop using it totally. The right to data portability is quite a neat one as well. So this is where you can ask for a copy of any information or any data held about you to be given to you, so you can use it elsewhere, and it has to be in a standard format. Now, preferably in an electronic format, but give you an idea, GDPR states that a common format might be Excel. So they could actually pass that to an Excel. If there's the ability to pass information to who you want it to go to in an electronic format, then that has to be implemented as well. Now, an example there might be where you have applied for a loan or financial information or something like that. You put in, or perhaps an insurance quotation, you put in all your details and you want to take the information and share it with other aggregators or other companies. You have the right to do that. The right to object is a neat one as well, and this is where you can object your data being processed. Now, this is where one of the areas you can object is with direct marketing. So if you're fed up with PPI calls and people contacting you, you can object, and if it's a direct marketing company, they have to comply immediately. So it's going to be interesting to see how that works. It'll certainly make my life a bit easier. Also, object it being used for profiling. Perhaps you're walking about a shopping centre and you're scanning items, and there's decisions being made about you that you may not know are really being made in the background. So it's quite a far-reaching one. The last one, Peter, the automated decision-making and profiling. This is where that you're taking this. This is where there has to be, or you can object to a decision being made about you, perhaps if you apply for a job or an online application without human intervention. This is where you can express your point of view. Is that your understanding of that as well?
Basically, I mean, this one really does sort of baffle me, and it really feels like it's so almost, it's quite imaginative. I mean, we have automated processes in place and have done for a while, and I mean, even the wording of this, you have a right to, you know, I just don't see how this is kind of going to work in the immediate future, because how do you object to something that's automated? And I mean, again, we're going to need the kind of infrastructure around this to actually, you know, if you're not just shouting into the void when something has happened, you know, it's going to need to be supportable for each kind of man, woman, and child.
I think it is design. You're right.
So tough, so tough. And you know, again, like a lot of people I've spoken to, just kind of don't see how this is going to come in time and actually work. So it's a great concern, this one.
Yeah, definitely. I think one of the areas that it can be used is if you apply for a job online and the decision is made to reject you purely based on a computer program, you can request that you can express your point of view. But I agree with you, that's going to be difficult to prove if you don't know that it's an automated process in the first place.
Exactly, and there's so many layers of excuses that can be used about which part of the process has been automated and which hasn't, that the kind of inquiry it would require to actually uncover everything is just going to take so long and be so expensive that I think this one's going to cause a load of problems.
So one of the, did you know, so breach notifications will increase substantially, and that's a statement rather than a question. It will increase substantially because now you have to notify the supervisory authority of a breach, and let's say you have to notify within 72 hours. So whereas with a directive, if you take something like Yahoo, I think they took possibly up to 2 years to actually notify the breach or become aware of it.
Yeah.
Quite an interesting one there. What's your take on that, Peter?
Yeah, again, it's sticky. I have an extra did you know to add to your did you know. The Tesco example, we spoke to, I can't remember where the lawyer worked, but they estimated that if the Tesco thing had been discovered in 2018, they'd have been charged 1.9 billion as the fine.
Wow. Which
I think is the most amount of money that ever would have been fined for that kind of problem in probably the history of the world. I mean, at the moment we're looking at $250,000 for, you know, say PlayStation, where, you know, when all of their user details kind of was being sold on the black market on a daily basis for weeks. I think it was 200K they got charged. Wow. So we can move on to this later, but yeah, you know, by these rules, Tesco would be looking at nearly 2 billion quid.
Wow. You could almost put companies out of business, couldn't you?
Never Tesco. I don't think Tesco's got considerably more than that. But yeah, you're right. Scary.
Okay, so what does it mean for businesses? Well, there's two words here that are really important, technical and organisational. Now, there are technical and organisational measures you can put in place to ensure that you comply. And the good news is, it's not all doom and gloom, is that if you do implement the recommended technical and organisational measures and you do have a breach, then you will be looked at very leniently. The whole idea is not to make money out of just finding people, it's to ensure that people do comply with the new laws. And I've listed some of the technical measures you can put in place, just making sure your policies and procedures are updated and are actually there. And the audit trails, so if you have an audit trail to prove what you've actually done with people's data and why you've done that, and the reason, the consent that you have to actually do something with their data. I've put in quotation marks certification. So one area that you can really work well and really try and protect yourself is to have certifications, loosely speaking certifications. You can get third-party companies to actually evaluate your policies and procedures, perhaps try a privacy impact assessment, to say, actually, there's a seal of approval here to say that we've tried to do some penetration testing to break into your system or access data, and we couldn't. Then you've got a seal of approval or certifications, and it's actively encouraged under GDPR for companies to seek this sort of certification. The two bottom ones, encryption and pseudonymization, is really where you can help yourself. If you can encrypt data, make sure the key is kept elsewhere. In the event of a data breach, if you have a breach and the data is unusable because it's encrypted and it's extremely difficult or impossible to actually view that data in any way, you're pretty much covered. GDPR is very lenient if you put in all the technical measures that you can. And pseudonymization is, and I could talk for about 30 minutes about that, obviously I won't. You can pseudonymize data, so as long as it's not relatable back to you as a person, then that's another way you can really be covered. The organisational measures, now some of these are already there with the Data Protection Act and Data Protection Directive. You have to appoint a data protection officer if you are a public authority or if you large-scale systematic monitoring or processing of data. So not every company has to have this, as you can see from there. A lot of companies already do have a data protection officer, even though they're not required legally to have one, such as financial institutions as well. Where it really changes is controllers, so people that control how your data is currently processed. They're typically the same people that will be controlling how your data is processed under GDPR. They can be sought for compensation if there's a data breach. So legally, they are responsible and compensation can be sought from it. Processors can't at the moment. The people that process your data do it under the control, under the authority and the BDI of the controller. Whereas under GDPR, processors can. So if you ring up, I keep picking on insurance companies, bless them, you ring up an insurance company and provide data to somebody on the end of the phone, in a call center, and they process your data, they could be sought legally for compensation. Hopefully unlikely to happen, but the idea behind it is not to penalise people, it's to actually it's always to scare companies into making sure that they comply.
Donnie, just to add to that, and correct me if I'm wrong here, but this is something I definitely heard once, or was told once. If a breach happens to you, are they not talking about forcing a company to get a DPO in, kind of as a one-strike punishment almost to stop it happening again? Yeah, I thought that was quite interesting as well. So it's almost like if you don't want to take the expense of hiring one, you may have to anyway if you don't. So it almost may be good advice to look into doing that, even if, as you say, just get someone to dual role it, or get the CIO to do a training course. Or
yeah, you're exactly right, Peter. And that's one of the areas. If you already have a DPO, when you don't have to legally have one, and there is a breach, you'll be looked on very favourably. Yeah.
Good stuff.
Okay, so what can you do to prepare for GDPR? Now, we've picked the top 5 areas just to try and cover the spectrum as we possibly can, and we'll go through each of these individually. But before we do, I saw this, and it's a recent study. It's a 2017 study where Bloomberg had stated that 87% of UK companies rate security as the highest risk item. Good, so they should. But only 5% of board-level employees have the expert knowledge in that area. What do you think of that, Peter? Is that do you find that common?
I'm going to side with the board here to an extent. I mean, I don't think that the board should have to know in depth. You know, it's kind of what IT is for, in my opinion. Although that's what your DPO is for. If we're being really topical, the board have a lot of decisions to make. I think it's important that you've got the right staff to communicate with the board. You know, those are always the people I most enjoy meeting or talking to, people who actually can go in the boardroom and make a case as opposed to being terrified of it or slightly dismissive. So yeah, I'm siding with the board, Donnie.
I agree with you as well, Peter. I think it's the team around you, isn't it? It's making sure that you've got the correct structure in place.
Absolutely.
So one of the items, identify what data you use and retain. I call this tidying your house up. So just make sure, and you can do this now, that the data you currently have under the existing directive, make sure you know what you hold, why you hold it. Just check if the original reason that you acquired that data is still valid. And if it's not, get rid of it. So really just get rid of as much data as you possibly can that you don't need anymore. Just make sure that the original reasons are there. If you're not using encryption technologies or pseudonymization, I would really recommend looking into that as really a matter of urgency, because that will protect you in as many ways as you possibly can. I mentioned the audit trails, so make sure that you know where the data came from, make sure you know what you're doing with it, so in the event of a breach, you can prove a legal basis for everything that you have been doing. And we mentioned before, document the third parties who you share the data with. Sorry, go on.
I was just going to say, I was on a panel with it was the CIO of a university recently, and I mean it's pretty much what you just said, but she just said, you know, follow follow the trails, get used to following the trails, get used to kind of, you know, visualizing where your data is as just a load of connected things, and just go as deep down as you can, because you're going to find data in places you never expected it to have gone to. Like if you've got so many departments in your business just kind of running amok, just kind of filing things and saving things, you know, it's really important to kind of think outside the box, really, just to find it all.
Yeah.
That was her advice.
That was great. Yeah, great advice, actually. Yeah, definitely. Yeah, definitely. It leads on to, as we mentioned, having the GDPR responsibility framework in place. Peter, a great hint there is you don't have to employ a DPO, or you can nominate, as you said, dual role. Typically, somebody pretty high up, chief security officer or similar. You know, make it their responsibility as the leading authority within the company, and that people, you know, the supervisory board looks very favourably on you. The comment I made here within my own company was, I'm going to presume that everybody knows nothing, and that nobody knows anything about GDPR, and I'm going to question people to see if they do know about it, and where I know something about it and that I know is correct, I'll tell them. And just like to say, I've done that myself, and I think it's a good tip. Just presume nobody knows anything about it and keep on talking about it to as many levels and layers of people as you can, just to see if they have anything got their interest in it.
Yeah, something I'd add here, which I think I'm still entitled to say, I really don't think there's enough governmental kind of training or pamphleteering on this. So I feel like certainly in the past 6 months or so, or a year, a lot of people have been almost waiting for the government to say something. And I think maybe in the situation we're in now, where let's say the government have got their minds on other things, I really don't think you can just wait for like a big poster to go up, sort of thing. I almost think we're past that point now. So it's unfair, because you really are on your own with this one. Like, you're going to start getting massively kicked with fines soon, and I don't think there's going to be a point where that becomes a matter of big public knowledge. No,
I agree. And I think the one thing we do know is that the 25th of May 2018 isn't a project date that's going to change. It'll be implemented regardless. And the policies and procedures, so this is really for employees to make sure that policies and procedures are updated, current, and that there's a continuous improvement plan. We're all guilty at some point of putting in a policy and procedure and thinking we'll revisit it every 3 months or 6 months and never going back to it. You can't do that now with GDPR. You have to make sure your policies are up to date. So look at your current policies. They still apply. They might need a bit more weight behind them. And make sure that people know what the policies and procedures are that they're meant to be following as employees, where they can access them if they forget or they just need a refresher. And make sure that in the event of a breach or anything that happens on GDPR, that you actually know where to go to get that process and policy from.
Yeah.
On this one, I just want to very much aware of the time, so I'll talk a bit quick at the embrace GDPR as part of your working life. Now, the terminology is embrace it by design and by default. So, privacy by design, this could be not just an employee processing data, this could be a developer who, as we have here at HelpSystems, lots of them developing software. Just make sure that they know that best practices are followed in every area of every aspect of their working life. And just think a bit more securely and be much more aware that we are really responsible for what we do with people's data. And we hope that people who use our data in the similar roles will be as responsible.
Yeah, just very quickly, I know we're kind of running out of time, but it's a bit of a kind of holistic comment on this whole thing. But we were speaking to Sainsbury's CDO, Andy Day, recently, and you know, in terms of this kind of making it part of your life, he just said companies should think of themselves as part-time custodians of their customers' data, using it in a way that enhances their relationship with the company. He said he thinks GDPR becomes a regulatory lens through which just to see that simple truth, really. So if you're genuinely already acting in the best interest of your customer, then GDPR should almost just become a side issue. Like, if you're just being proper and being correct, none of this stuff should bother you. And I thought that was quite a good sort of philosophical point, really.
Yeah.
Just be nice. Be nice.
Yeah, definitely. Yeah, that's great. Yeah. And prepare for a data breach. So make sure that you recognise a breach when it happens and have a policy in place of a step-by-step process what you're going to do when a breach actually happens, including who you're going to tell, how are you going to notify them, who's responsible for telling them, how are you going to stop the breach and prevent it happening again. Now, 72 hours, at the moment you have to report a breach in a reasonable period of time. 72 hours, you may not know what the breach is. You might just know there's been an attempted breach. You may not actually know the details of it. That's okay. GDPR allows you to notify breach information in phases. So you can actually say, we've had a breach, we don't really know the extent of it yet, but we're looking at it. The important thing is that you actually notify people of the breach, because if you don't, this is where the scary bit comes in, the fines. So the impact of the data breach, I'll split it into two. There's two levels, but you can see that in the first level, up to 10 million euros, or 2% of the total worldwide turnover. One of them is failure to report a data breach. So if you don't report the data breach to the European Data Protection Board within 72 hours, you are liable, or potentially liable, up to a fine of 10 million euros. And then Peter kind of mentioned earlier that it's worth having a DPO, even if you don't have to have one. And and also, if you have a breach, you might be forced to actually employ a DPO or appoint a DPO. It's quite right, and that's one of the reasons that you can have a fine of up to 20 million, or 4% of your total worldwide turnover. Just to brief that, we have an office in France, a few employees in there. If one of the employees in France caused a data breach, HelpSystems globally, within 21 different locations, could potentially be fined for 2 or 4% of its total previous worldwide turnover, not just the office. Any comments on that, Peter?
I mean, it probably more or less goes back to what I was saying earlier. These are huge fines, and this is going to be a massive change to the way people really think about privacy generally. Looking at history, I think some form of legal precedent is going to have to come into play. Like, say it was Tesco, got this 1.9 billion fine, that would kind of set the benchmark. And that, I guess we're going to be looking at kind of a showcase of that. But otherwise, yeah, they're just huge fines, and I kind of wonder, not that it's going to be hard to enforce, but just that it may be considerably after 2018 before the really big money starts to be charged.
It's certainly going to be interesting to watch that, isn't it? Absolutely interesting, yeah.
Yeah.
Okay, right, we're pretty much out of time, so I'll just wrap up at the moment. Now, I've spent a lot of time, as has Peter and various other people, looking into GDPR. It's something I'm genuinely really interested in, so anything at all that you want to know, if I don't know, I'll certainly go and find out. So use me as much as you want. There's a number of articles, I won't say papers, I'll try to keep them short and bite-sized. A number of papers that have articles on the HelpSystems website you can look at, you can download and use as you wish. And we do have a 30-minute session with the GDPR team, either myself or our President of Security Services, Robin Tatum, and there's a couple of other people involved in HelpSystems in various locations that can give you their take on GDPR. Anything you want to know on that, do just get in touch with us, and we'll happily spend at least 30 minutes with you. Very much where we're at, a couple of questions. In fact, there's a number of questions. Thank you, Mr. Mundy. I'll contact you separately. A couple of questions I got asked pretty much every time I talk about this is Brexit. How does it affect us with Brexit, and will this change? No, I mean, it won't affect the Brexit. This will come in almost certainly before we leave the European Union anyway, by the simple fact that we are dealing with employees and customers. Targeting customers is one of them. You don't have to have a physical presence. Even if you just have a website in euros targeting European customers, then you fall under the rules of GDPR. In fact, Peter, do you want to comment on Brexit, or are you?
I agree with you in part, but I also have definitely heard dialogue from a few people questioning whether, if our Brexit policy on data privacy was to take a bit of a dogleg or a funny turn, because we have got a bit of a local history of data collection and getting quite kind of, almost draconian about the way that we deal with data. So I do wonder if there may be conversations had to try to stake a claim as to where we actually sit within GDPR. But I do also think it's probably most likely that we'll base any of our policy that interacts with the European policy is probably quite similar, because let's face it, we've not got a lot of time to come up with something different.
Sure. Yeah. I think you're right. Stick with what you know. Just make sure it complies with the rules of GDPR. Absolutely. Good. Okay, there are some other questions. I will respond to each and every one individually. I just want to thank everybody for attending and taking time out of your busy schedule to join Peter and myself. And Peter, I also want to thank you very much. I certainly owe you a coffee or two. And
it's a pleasure, Donnie. Absolute pleasure. Thanks everyone for attending. I hope I was useful.
Absolutely. Thanks very much. Thanks. Bye, everybody. Thank you.
Thank you. Bye-bye.